Thank you all for being here for this event, which is being co-hosted by the Birnbaum Women's Leadership Network, the Center for Diversity, Inclusion, and Belonging, and the Center on Race, Inequality, and the Law. And the title, From Anita Hill to Christine Blasey Ford, Looking Back and Looking Forward, describes pretty accurately exactly what we hope to hear about from both Professor Melissa Murray and Professor Kim Taylor-Thompson. I think neither of them needs an extended introduction from me for this audience, but we are very grateful all days, but these days in particular, that they are members of our community and leaders of our faculty and our school. Let me also, just before I turn things over to them, put in a plug for an upcoming event that I hope you'll all find time for as well, being hosted by the Center for Diversity, Inclusion, and Belonging, called Time's Up for Sexual Harassment, Litigating Social Change. And we will have as our guest Roberta Kaplan, who is a renowned litigator and co-founder of the Time's Up Legal Defense Fund, in conversation with Professor Kenji Yoshino. And the date for that is Wednesday, October the 17th, so 2 weeks from today at 4:30. I hope you can join us then. For today, let me just say this. From even before the formal nomination of Judge Kavanaugh to the Supreme Court, it was obvious to everyone that the nomination of the successor to Justice Kennedy was going to be momentous and almost certainly controversial. Whether they admit it or not, virtually all of the supporters of the Kavanaugh nomination, and I'm talking about the period before the allegations from Dr. Ford and others became publicly known, virtually all of the supporters of the Kavanaugh nomination and virtually all of the opponents of the Kavanaugh nomination agreed very broadly on a number of key factual matters, like what was Judge Kavanaugh likely to do in a range of important, in particular, individual rights-related constitutional issues as a justice on the Supreme Court. Their disagreement was on whether they thought that was a good thing or bad. Some of the support for Judge Kavanaugh has recently suggested that there are unfair predictions among the opponents of the Kavanaugh nomination about what he will do as a justice. But make no mistake, a very large fraction of the support for Judge Kavanaugh is based on exactly the same predictions and just being more pleased about those outcomes. So there was plenty to talk about, to discuss, to argue about in this nomination, up to and through the first set of hearings. And I hope all of you had an opportunity to see the testimony provided by Professor Murray in that context. Plenty of controversy, surely one of the most consequential nominations to the Supreme Court in its recent history. But then, either everything changed or at least a completely new set of issues came to the fore with the making public of the allegations brought up by Dr. Ford, not only, of course, deeply complicating the question of Judge Kavanaugh's nomination, but linking that nomination in a more immediate way to a set of issues that go well beyond the Supreme Court, that are about issues of sexual violence in society today, that are about what happens to victims of sexual violence when they come forward with those allegations, that are about questions of power and privilege in this country, and the relationship between power and privilege and allegations brought forward by people claiming to be victims of sexual violence. They are about, too, how to reckon with allegations when they involve events said to have occurred many years in the past, and how to think about what one would need to know to arrive at a point of certainty in those circumstances. In all of that, they also provide an opportunity for us to think back. They almost demand that we recall the last time questions of sexual harassment arose in the context of a Supreme Court nomination, and that, of course, was the nomination of Clarence Thomas to the Supreme Court and the allegations brought forward by Professor Anita Hill. Professor Taylor-Thompson was on the legal team representing Professor Hill at that time, and so for that, among many other reasons, is ideally situated. So I will not keep the mic any longer. I look forward to hearing from both of our speakers today. Please join me in welcoming them.
So thank you for being here, and if any of you are kind of standing in the back, there are a couple of chairs up front, so if you want to sit, you're more than welcome. You don't have to sit on the floor or stand. What we wanted to do, just to kick this off, is to give you an understanding that we were asked to have a conversation about the events that happened 27 years ago and happened just a week or so ago, and to perhaps draw some parallels and give you our sense of our impressions of what occurred. This is by no means intended to be the only way you can perceive these events. We are not trying to give necessarily a balanced perspective on what, these are our impressions of what we saw. And the way that we'd like to begin this is by giving you some comments ahead of time. So I will start and Melissa will chime in a moment. And then we are going to ask each other some questions so that we can have a bit of a dialogue here. And then we will open it up to you. There are some folks out there who will be running around with microphones so that you don't have to shout your question. Just kind of raise your hand and they'll get to you with the microphone. So that's the process that we have, and we have about an hour to do it. It's obviously not enough time to talk about all of the issues that are in play. So we'll try to touch on the issues that we think are salient. But if we're missing something or you think that we should be addressing something, please raise it in your questions. So I'm going to start by talking about 27 years ago. In 1991, I was in D.C. sitting behind my friend, Anita Hill, as she testified in the Clarence Thomas hearings. And it was surreal in so many ways. I vividly recall sitting there and feeling that everything seemed larger than life and fundamentally warped. It was a very disturbing set of events. Professor Hill was sitting there in front of 14 white men who were senators on the Judiciary Committee. And I fully expected that they would question her and question her intensely to test her credibility and the accuracy of her statements. She had raised a question about Judge Thomas that had not come up in the initial set of confirmation hearings. And it really went fundamentally to his fitness to serve. So I expected a rigorous inquiry. But even as a seasoned defense attorney, I didn't expect what she got, partly because it's not something that would have been tolerated in a court of law. But we were not in a court of law. We were in a room that had no rules, no expectations set, no boundaries. So I watched as these 14 men engaged in a series of demeaning questions without any constraint and without any shame. These senators made baseless accusations about the sanity of a person I knew quite well. And they made sure to send the message not just to Professor Hill, but to everyone out there that she who wants to make such an assertion does so at her peril. So let's start a little bit with the context at that time, just to give you a sense of taking you back in time a bit. In 1991, issues of workplace sexual misconduct or sexual violence and the power dynamics and pain involved in that were much less understood and certainly were less discussed openly. Women might have shared stories about this with each other, but even then we tended not to do it in very broad circles. We kept it private and moved on. So when Professor Hill walked into that hearing room, and into the living rooms across the country, it wasn't on the heels of a Me Too movement that had brought those issues into the public conversation or the public sphere and had at least surfaced that practice could no longer be simply ignored and that people in power could simply get a pass. It was in a setting where those claims were not taken seriously, in a setting where senators didn't understand the issues or were unwilling to understand the issues, and understand what was at stake. So, as I mentioned, the process was that there had been a set of initial hearings, just like in the Kavanaugh hearings. There were hearings that occurred where people testified about Judge then Thomas's abilities and his fitness and the concerns that people might have. But and those hearings had closed. There was an FBI investigation in which Anita Hill's name had come up, and then she was interviewed by the FBI. And her statement was leaked to the press. And so after her statement was leaked and the information started to come out, a hearing was set for a couple of weeks later. And the process in those hearings quickly degenerated into no process at all. Professor Hill was examined and actually cross-examined by Republican senators who were intent on showing that she was lying or delusional. And outside the hearing room, they were even less restrained. Most people who watched the hearings at the time and who certainly have looked back at those hearings were angriest at the Republican senators because of their behavior and how they questioned her. At the time that I was sitting in that room, I didn't like what the Republican senators were doing, but I understood it. They were playing partisan politics to the hilt, and they were protecting their president's nominee. But then and now, I was angriest with the Democrats. They controlled the Senate, they controlled that committee, and they ceded control to the Republicans. They established no guidelines or process. They couldn't defend Professor Hill, in part because many of them, like, for example, Ted Kennedy, were compromised by their own misconduct. And so their voices were muted, and she stood alone. And her credibility was questioned in ways that reflected not only her gender, but her intersectionality, her race and her gender. But she withstood the question. She, too, passed a polygraph, and she presented credible evidence to the committee. And afterwards, she received death threats, just like Dr. Ford. And after that, her life was forever changed, and Clarence Thomas ascended to the court. If we fast forward to last month, even though 27 years had passed, it didn't feel like much had changed. Yes, we were spared the sexist and demeaning questions by the senators, since the Republicans outsourced their questioning to Rachel Mitchell, the former sex crimes prosecutor from Arizona. So it seemed that the senators on the Judiciary Committee had at least understood the optics lesson, right? But much like Professor Hill's testimony 27 years before under Senate questioning, Dr. Ford's testimony was not shaken under her questioning. But what became clear in the discussions outside of the hearing, when the senators could actually grab the microphones, and even inside when Senator Lindsey Graham treated us to his emotional meltdown, was that they understood the optics, but they still didn't get the substance. So let me talk a little bit about similarities, and then I'm going to hand it off and stop talking. Both Professor Hill and Dr. Ford were treated as the accused, right? They were put on trial for coming forward. What's her motive? She needs to prove to us that she's not lying, because the presumption is that both of them had an axe to grind. Both of them had a political or personal vendetta, that somehow they wanted this attention because they were really just a pawn of political conspirators. The conspiracy claim was raised in '91 and in the current hearings. And really, how obtuse can you be? Who would want to come forward and confront those kinds of accusations, those kinds of threats, and particularly Dr. Ford, who knew, having seen what happened to Professor Hill, to say that somebody would want that kind of attention seems to me at least to be ludicrous. Professor Hill and Dr. Ford, as witnesses, shared some similarities as well. Both of them told their stories in painstaking, difficult detail. Both were careful not to say more than they knew. Professor Hill gave facts, but would not draw conclusions that Clarence Thomas's conduct constituted sexual harassment, but she gave facts from which one could draw that conclusion. Dr. Ford similarly made clear when she was sure and when she wasn't sure. She wanted to help, and she thought that records might enable her to be even more accurate with respect to timing. When she was sure of something, she said she was 100% sure. When she wasn't, she said she wasn't. But they both relived experiences that helped you see what happened and feel what happened. And another similarity between the two events was that both events limited the discussion to two principal witnesses. It was Professor Hill versus Clarence Thomas. It was Dr. Ford versus Judge Kavanaugh, when there were other witnesses that could have been called in both sets of hearings. We wanted to distill it to a he said, she said, and that's what we did. And then we had the reactions of the nominees. Both judges were quite similar in their behavior. When I watched Kavanaugh the other day, my first thought was that he had taken a page from Judge Thomas's playbook. They both came out angry and swinging. They both called the proceedings a circus, as though the issues that were being raised were somehow a sideshow to the real issues that were in play. Kavanaugh charged a Democratic conspiracy to discredit and silence the Democrats on the committee. God bless you. And Thomas pulled out his "this is a high-tech lynching" claim that dishonored those who had died before him to intimidate the Democrats on the committee. They were all white men on the Judiciary Committee at that time, and they didn't know how to deal with the racial dynamics that were in play. And so it worked for Thomas then, and my worry is that it may work for Judge Kavanaugh this time. So I'm going to stop there on that really high note and turn it over to Melissa.
Who has never been one for optimism.
There you go.
So I've been asked to talk about my own experience testifying, which is obviously very different from the experience that Professor Hill had in 1991. But in thinking about it, I think there are some commonalities and also episodes, I think, that presage some of the issues that have surfaced since the allegations of sexual misconduct have emerged around Judge Kavanaugh. So around the end of August, I was invited by Senator Dianne Feinstein to present evidence in the expert witness testimony portion of the hearings about Judge Kavanaugh's record on reproductive rights. And I said I would do it, but I was wary because at this point in time, none of this the misconduct allegations had not surfaced. Judge Kavanaugh's nomination seemed like a juggernaut that was just going to roll over everything and he would inevitably be confirmed to the Supreme Court. I'm not sure that that's changed, but it definitely looked like a clear path for him at the end of August. And I had known Judge Kavanaugh. For years when I was at Berkeley, I had run Berkeley's clerkship program and I'd met with him, had lunch with him. Republicans eat very rare hamburgers, I learned during that lunch.
Who knew?
Who knew? Who knew? So we had been friendly over the years, and I recognized that in testifying against him, I would be making an enemy. And friends advised me that if I did this, it would compromise my ability to send students to him in the future. If I wanted to be a player in terms of getting students to the court, this would certainly compromise that. But in the end, I really thought that it was important for the senators, and particularly Senator Susan Collins and Lisa Murkowski, to understand that his record on reproductive rights was pretty abysmal. And whether he would actually overturn Roe versus Wade, which I don't think he would do, he would never utter those words, but I think he would certainly, in effect, make Roe versus Wade a non-reality for most women in the United States, and I felt that was important to get across. So I decided I would do this. I'm very pleased to be at NYU, where the administration was very supportive of this, recognizing the risks and consequences, and sent me down to DC to do this, and I appeared in that hearing. I will say, the first thing that struck me about the hearing was the clubbiness of it. I recall watching the Anita Hill hearings. I think I might have been 15 or 16 in 1991.
Thank
Don't
you
figure
so
out my
much
real
for
age.
that.
Don't figure that out. But it just seemed like there was this yawning expanse between Anita Hill and the senators who were sort of lofted up in this sort of Star Wars senatorial, like hovering above her. And in fact, the room was not much bigger than this, and there wasn't that much expanse between the witness table and the senators. A lot had changed since Anita Hill, although not much. The Democrat side was now populated by women, women of color, and men of color. But the Republican side was exclusively white men, and their staffers were also almost wholly white men. So some things had changed, but not everything had changed. The other thing I thought was really interesting was the witnesses that were presented on both the majority side and the minority side. The majority side were almost, to a person, elites, former clerks of Judge Kavanaugh, the Solicitor General, the former Solicitor General, Ted Olson, people who had gone to college with Judge Kavanaugh, people who had taken his class at Harvard Law School, and then finally my own former professor, Akhil Amar from Yale Law School, who is seated immediately to my left. On the Democrat side, it was almost wholly women, with one exception, a congressman from the Congressional Black Caucus. There was a woman, Liz Weintraub, who is a disabilities rights advocate, Alicia Baker, who is a pro-life minister who had been prevented from getting contraceptive coverage for her IUD because her employer had moral and religious objections to coverage of the IUD. And then there was Rochelle Garza, who had represented the undocumented woman Jane Doe in Garza versus Hargan, the case that Judge Kavanaugh had heard as a judge of the DC Circuit. And then there was me. And I mentioned this to my con law class after it happened, but it's still so striking to me. As Senator Grassley went through and identified everyone and introduced them to the rest of the committee and to the audience, everyone on the majority side, he listed in extravagant detail, like this person is a graduate of Harvard Law School, and he clerked for Judge Kavanaugh and Justice Sotomayor, and he did this, and he's an associate at Winston Connolly, and Ted Olson is here. He's argued 100 million cases before the court. He's fantastic. Akhil Amar is here as a Sterling Professor of Law, clerk for Justice Breyer. And then he came to me, and he was like, Melissa Murray took a train here from NYU. Like, I mean, it was like nothing. And so, which to me was really interesting. Like, you know, as a woman and a woman of color, I had to actually take a minute and a half to claim authority to speak in that space and sort of, let me tell you a little about myself. And my husband was like, you spent a lot of time on your resume.
But you had to. I went to Yale Law School and I did these. So that's where you started.
So yeah. I mean, which I thought was really interesting and sort of, you know, a little crabbed of Senator Grassley to be that part, to be so obviously partisan in how he introduced people and setting the stage for this. And so, you know, then we gave our testimony, and there was this one moment where Cory Booker, who the senator from New Jersey, had finished asking me a bunch of questions about reproductive rights, and then he said he had this really important, very mean question for Professor Amar, who is to my left. And you know, I was like, what was this question going to be? Everyone was waited with bated breath. And then all of a sudden, Cory Booker asked, do you regret passing me in your con law class? And everyone laughs except me, who's like, seriously? This is the question? And you know, Professor Amar says something about, I actually updated my Wikipedia page to reflect that I was your teacher. And it was like the clubbiness of that moment. And it was in that moment I realized, like this was a room full of elites, and they all kind of knew each other. They'd been circulating. In some ways, I was part of it. In some ways, I was apart from it. But it was really striking, just in that moment, even on the Democratic side, that these were sort of the dynamics. And so, anyway, testimony finish. We leave. 3 days later, I think the first sort of inklings of these claims of sexual misconduct emerge, and you know, we're off to the races, and the dynamics change a lot, but not that much. Right. And again, just as there were women like Louisa Gary, who had been Judge Kavanaugh's classmate at Yale, and Colleen Rose Sindak, who had been a student at Harvard Law School, you know, this retinue of credentialed elite women stepping forward to rebut these allegations, and the sort of class solidarity that emerged to surround and protect him in the midst of this. And then, you know, Dr. Blasey Ford, who in that moment was not just a survivor recanting her or telling her story, but a class traitor recanting her allegiances to the place where she had grown up and how she had grown up. And to me, that was just a really kind of powerful dynamic, just and hard to do in that setting where the clubbiness is really palpable.
Yeah. So shall we trade some questions back and forth? We're going to give you a chance. Do you want to go? Okay.
So I don't think everyone understands this, but when Professor Thompson went to sit and support her friend Anita Hill, she's not alone. There are a lot of other people, a lot of them professors at various law schools, most of them professors of color. Almost all of you were untenured or at the very junior stages of your career.
So I'm not sure if Emma Coleman Jordan at that time, I think she was tenured, but the rest of us were not. So I had just started teaching at Stanford a month before, so I was really new. And then the rest of us were untenured, yeah.
And Charles Ogletree
Charles
was there.
Ogletree was untenured.
And this was a big deal.
Yeah.
And a risky thing to do as an untenured person, someone new to your professional community, taking a stand against someone who would later be feted as among the most elite within this group of legal elites.
Yeah, so I think that I was somewhat naive around what the risk might be, partly because Stanford was actually being quite supportive and encouraging me to go forward and to go. And frankly, Anita is a friend of mine, so there wasn't a question that I wasn't going to go. But people who had been in the academy for a little bit longer, like Charles Ogletree, who was at that point an untenured professor of law at Harvard. He and his wife talked about the fact that that this could have ramifications for his profession, for his ability to get tenure. Did he want to do this? Is this something that he ought to do? And again, every single one of them, and I'm not one of those people who had that in her calculus, but the people who did made the decision that this was important enough to go forward. But the risk was there. After the Thomas hearings, Anita went back to the University of Oklahoma, where she was a law professor, and state senators had moved on the Senate floor that she should be fired from her University of Oklahoma position, even though she had tenure. So these risks were there, but we just didn't realize them because we felt that we had to go do this, and it was important to do.
So when you saw Professor Ford testify, did it strike you as being similar to when Professor Hill testified, or very different? And if so, how?
So there were similarities and differences. The similarities were that both of them really were taking pain to help you see what happened and not go too far. And in the course of their conversation about what happened, you actually could picture what had occurred. You could relive it with them. And I think that in that painstaking detail, both of them took us to a place of pain that perhaps neither one of them wanted to go to, but they thought was important to help us understand what had happened. At the time of the 91 hearings, I was in the room watching, my friend go through this. At the time of these hearings, I was watching it with my 94-year-old mother. We were watching on TV, and she was saying, I'm so glad you're not there. I said, yeah, I am too. But the two of us were struck then and, this time and before, that there was something courageous and powerful in what they were saying. I think what was different was that Dr. Ford acknowledged the terror that she felt. Anita did not, but she felt it. What surprised me about the testimony that Anita gave 27 years ago was how calm she was. There's no way to describe what it was like to have the media coming at you. It felt almost assaultive when you would get out of a car with Anita and have all of these people surrounding you with microphones in your face and yelling at you and trying to get comments. It felt oppressive. And having all those cameras in that unbelievably imposing and sort of difficult room to be in, and she still sort of maintained her calm throughout all of that. And I think that was because she was telling what had happened, and she wasn't having to really make up anything, and so it was easier for her to actually get past the fear and actually say what was going on. With Dr. Ford, I think she was afraid, but you could tell that she was overcoming that and that she was finding a way to work through that to actually help people understand what was happening. So I saw a lot of similarities.
And Dr. Ford was praised for her vulnerability, whereas Anita Hill was pilloried for her stoicism.
Yeah. Well, I think that there are lots of issues in play on that one, right? That we kind of like the fact that Dr. Ford, or sort of the public likes the fact that Dr. Ford was looking to be helpful, because there is that perception that she's not, a mean woman. She really wants to be a helpful woman. And there are issues with, how do we have to appear in order to be believed, that I think come up in that. And with Anita, you had the race and gender issues both playing out in her testimony. Anita was seen as someone who, within my community, was seen as airing dirty laundry that she shouldn't have been airing. So we had a number of civil rights lawyers who had come out opposed to Clarence Thomas in the initial hearings, and they became quite silent in the Anita Hill portion of the hearings. So she was, in some ways, ostracized from our community. There were, I think that had the racial dynamics been different, so we have Justice Thomas, who he is, an African-American man, and if Anita had been a white woman who had been making these claims, I suspect that the Southern senators who were embracing Clarence Thomas might not have embraced him in quite the same way. So race was in play there, and so her ability to not fit a stereotype and to be seen as somebody who was stoic, that was used against her. Imagine if she had been emotional or shown some level of vulnerability, then she would have been attacked for that. So it was a very difficult line for her to walk.
I always thought it was so strange that Black women really rejected her. And Kim Crenshaw had this really amazing piece in the New York Times a few days ago, where she was also one of the professors who joined you in supporting Professor Hill, but she noted that one day you were exiting the hearing room and you saw a group of Black women clustered together, and you were momentarily buoyed because you thought that these were women coming out to support Anita. But in fact, as soon as you approached with her, the women dropped to their knees and began praying about the devil woman who had been sent to tear down this Black man. And in fact, they were there publicly supporting Clarence Thomas.
Yeah, the racial dynamics were working in ways that none of us expected. But white feminists also were trying to distill Anita's voice and to suggest that this is only about gender and missing the racial implications as well. So people miss the intersectionality and how that double burden of race and gender played out for her.
So, and Kim Crenshaw in this op-ed notes that that was a moment where the possibilities of intersectionality were surrendered to this kind of binary race or gender thinking, and that this perhaps is a moment where there could be more intersectional coalition building. Do you think that's true, or do you think those divisions are exacerbated by this testimony?
This one. I actually think it's truer now. I think that you actually can get to a point where people are seeing issues, not only gendered issues, but I think that you're hearing voices of women of color right here talking about how we perceive those issues. And so I think that there probably is an opportunity to bring people together a little bit differently on this one. It is not as polarizing because race is not in play.
But what about in the larger Me Too movement?
So it's a great question. You know, what is lovely about the Me Too movement is that it has raised these issues and it's brought it to the fore. But when you look at why it got raised and who raised them, it was often white women who raised it, women who were of a certain socioeconomic status, so a certain level of privilege. And it was as though these issues were now issues that we could pay attention to because we now believed the person who was saying it because they looked different. Those same issues had been raised 27 years ago with a different person who looked differently and were not credited in quite the same ways. That's not to say that Anita's testimony didn't make a change, right? It certainly did raise these issues. You wouldn't have had a Dianne Feinstein on the committee but for the Year of the Woman that happened after these hearings, when women just said, we're going to run for office because we're not going to have another situation where it's just men making these decisions. But even in that bit of a change of a political environment, we did not see the kind of change that I would have expected, certainly not the transformative change. So we saw the Me Too movement come out, and folks like, what was interesting, I think folks like Jane Fonda said, you know, weren't these issues raised by Anita Hill about 27 years ago, and why are we acting like this is new? And is it because it's, you know, somebody that looks like me that's raising it, and now we can credit it? So the Me Too movement, I think, has to really begin to recognize that there are race issues and gender issues. And the fact that Anita has been selected to be the head of some of the efforts around Me Too, I think will actually help to make sure that that happens.
I think one of the areas where maybe more thinking needs to be done is with the whole question of due process concerns, which not everyone, but some people who have been prominent in the Me Too movement have been really dismissive of due process protections for those who are accused. And you know, I said this back in January when we did the Me Too Latham and Watkins forum, but you know, as a Black woman, that really gives me pause.
Absolutely.
Just for lots of reasons, like due process has to mean the same thing. It cannot be an itinerant commitment. Right. So if you care about due process for people on death row in Alabama, you have to care about it even for people you find morally objectionable.
Exactly. Exactly.
And that's something I think that's missing in the Me Too conversation. I think it's more attention to that issue would do a lot to bring women of color into the fold who are thinking about situations in their own life. I mean, like when I was in high school, there was an African-American football player who was caught in an amorous circumstance with a white teenager, a cheerleader, and her parents went crazy. And, you know, she knew her parents would object to this. She made some noise about it being coercive, but in fact it hadn't been. But in that moment, she couldn't tell her father and her mother that in fact she was consenting to this. And it took several days for the whole story to come out. But in that moment, the terror that that young man felt, thinking that his whole life would come crashing down because she reasonably was worried about what her parents' reaction to this dalliance would be.
And so the issue is that when we look at issues of sexual misconduct, sexual violence, that it is not something that's simple. It often has a level of complexity that you can't just ignore. And this racial history that we're talking about, it's not just something that somebody in your high school experience. There is, you know, a racialized history around Black men being accused of sexual violence. And so there needs to be, I think, a nuanced conversation, and a due process filter needs to apply. But we need to have those conversations so that we think about what does this look like for people of different races, people of different socioeconomic statuses, and that's the conversation that I think needs to happen, and that's the conversation that did not happen in 91 and really is not yet happening. So I'm going to ask you one more question, and then we're going to throw it out to you. You know, one of the things that I've been thinking about is if Judge Kavanaugh is actually confirmed and he becomes a member of the court, what do you anticipate will be the impact of these hearings and his you know, wounded feelings when he has to decide issues of you know, raising women's rights, abortion rights, or other individual liberty questions that he might consider to have been raised by what he referred to as left-wing organizations. So what do you think he's going to be like?
I don't know how you come out of something like this and emerge unscathed, right? He very much believes that he is not the person who did these things and that he has been unfairly targeted. He He never called it a high-tech lynching, but he came pretty close.
He did.
I don't think you can sort of easily cast that off and then set about calling balls and strikes. And his display of temper in that hearing was shocking, at least to me. I mean, it was more John McEnroe than John Roberts. And he really needed to be John Roberts in that moment. So I think, were you to have a Bush v. Gore with Justice Kavanaugh on the bench, I mean, I assume he would line up with the conservatives on a decision like that. And I think we would predictably expect him to take the conservative position, especially with this in the rear view mirror. And I think the bigger question is not what is he going to do, but what does it mean to all of us that he does it? And in that sense, I think, I've talked about this in con law, but the court does not have the power of the purse. It doesn't have the power of the sword. It depends on its legitimacy, its temperateness, for us to take it seriously and to take what it does seriously. And I think that has been profoundly impaired by these hearings. And I'm not sure that wasn't the point. I mean, we have an administration that has gone about completely undermining and delegitimizing every institution that would serve as a bulwark against excessive state power, whether it's the media or opposition groups, and now the court. Of course, it would make sense to delegitimize the courts in the eyes of the public. That's what you do if you're a despot.
Which he is. Which he is. And you're right, he has taken every institution and attacked it. The presidency, he is
It's unrecognizable.
It is unrecognizable. And the FBI, they're just a bunch of idiots, according to him.
But they're doing a great job doing things we have not even seen before.
Oh, yes, it's amazing. And then the way that he mocks people, and in fact mocked Dr. Blasey Ford just last night at a rally in Mississippi. It just sends a message that we don't have to take any of this seriously. Not only do the institutions not matter, but the individuals don't matter either.
So can I end on a slightly hopeful note?
I think we should.
Okay, this is not characteristic of me. I'm usually the most pessimistic.
Okay.
If he is appointed to the court,
Yeah.
That obviously will have enormous repercussions for questions of individual rights and individual liberties. But that doesn't mean things are out of your hands. So I'm thinking a lot about reproductive rights, and you may be thinking about different things, but for abortion regulations to get all the way up to the Supreme Court, first they have to be enacted.
Yeah.
So where is the righteous indignation and mobilization around state legislative races?
Right.
Right. Where is the righteous indignation and mobilization around governors' races, like the one in Georgia?
Right.
I mean, a governor can veto something that a very conservative legislature enacts. Governors can appoint justices and judges to the state, intermediate appellate, and high courts. I mean, those are really important mechanisms of resistance, if that's what you're interested in. It's not just the court that is a bulwark.
And I think that one of the things that has happened, particularly over the past couple of decades, is that we have looked more and more to the court to answer. I'm losing it. To answer these questions. I'm good. Answer these questions, and you wanted to take things to the court in some instances. Certainly in the areas that I practice around adolescent development, it made sense to go to the court because they were actually carving out some things that were helpful to our clients. But now that you have to have different strategies. It can't be to go through the federal system and up to the Supreme Court. That's probably the last place you want to go. So really think about what can we do to affect change on the state level, what can we do to affect change in the public consciousness, are there certain things that we can do differently? It means that we as lawyers need to have different arrows in our quiver in addition to what we might have done in a litigation context. So let us open up the floor. If you have a question, we have somebody with a microphone. If you don't have a question, we can all just walk out of the door. Do you have a question? There's one. Hi. The mic is coming to you.
Hi. Something I've been struggling about watching this is I'm realizing that I have multiple fundamental values that are kind of coming into conflict here, in that I fundamentally believe that what he did disqualifies him from being on the court. And also, I fundamentally believe that 17-year-olds are less morally culpable than adults. And I've been really struggling with how to navigate those two values.
Yeah.
So I don't know that I have a question, but.
No, and I think it's a great question, and it probably makes sense for me to play with that one, right? Because I certainly write about the fact that when you're thinking about somebody who is a teenager making decisions, that those decisions are not the same as an adult making those decisions. Kids may behave more impulsively, they're developmentally at a different stage, and so they don't have the proper functioning of the executive functions that we might imagine when we're thinking about someone making the choice to engage in this behavior. And if we're going to take the Brett Kavanaugh situation and credit what Dr. Ford said, then add alcohol to that, and the decision making is even worse, okay? And other people being in the room, you do things with peers. So all of that is in play. For me, what that means is that you look at that as a factor to consider. It is not the only factor that you consider, but you look at that, and you also look at it through a developmental lens. What was going on with him at that particular time? What was he like? What were some of the things that were going on that help us understand why he behaved as he did? What tips the balance for me is that there's a pattern of conduct. It's not just limited to that one incident if we believe the various people who are coming forward. And it suggests that this is not something that is just, he made an error in judgment as a kid, but it's a set of behaviors that has allowed him to continue to feel that he can behave anyway with other people, and he can excuse that conduct by saying, I had too many beers. And so for me, it doesn't feel like there's an inconsistency. It actually feels like I'm willing to at least think about the weight that I want to apply to that earlier incident. It still has some probative value if I'm going to pull on some evidence concepts here, but I don't think that it is enough in and of itself. For me, it isn't. I needed to see the other acts of misconduct to actually help me understand who he is and what he does. And I think that what you saw in his belligerent testimony gives you more of an indication of who he is and why he's unfit. Can you imagine a woman who is being considered for that position coming in yelling and screaming and actually being considered for the position of justice for a lifetime appointment? Wouldn't happen. A person of color coming in there screaming and yelling and saying, did you black out? Really? Do you think that they would be considered? There's a level of entitlement and a level of privilege that I think was on display that was peaked at, that we noticed earlier. It was an example of that entitlement when he was younger, and he has not seemed to have grown out. He has not grown out of it, in my view.
I think your question, though, suggests the difficulty of intersectional feminism, because on the one hand, you want the conduct of a 17-year-old to be impactful in this instance, but you also recognize that if it is, it will then be marshaled against probably young men of color in the future. And maybe one way that I think broach it is, this wasn't a criminal trial. I don't even know if this was a civil hearing in the real sense. I mean, this was just, do you 21 members of the Senate Judiciary Committee think this person should be on the court? I mean, it's not even a preponderance of the evidence standard. It's just sort of a gut check. And I think in those situations, I'm not saying it's low stakes. It's obviously very high stakes for Judge Kavanaugh. I mean, and you see the result of that. But it's not the same as a deprivation of liberty. And I think you can sort of weigh them differently in those contexts.
Thank you. I have a question relating to the concern that you raised about the due process, generally in these, I guess, Me Too situations, where I find it hard as a white male to, on the one hand, try to be considerate that I still want to have some proof. We can't just have or an allegation ruin somebody, but on the other hand, taking these allegations seriously, because I think often in contexts of sexual misconduct, you won't have any evidence or witnesses that can corroborate these allegations. So I would just like to hear your situation. What do you think needs to be proven to take allegation or to take action on allegations, and how should we behave when talking about this without trying to belittle potential victims of sexual allegations or just shoving it under the carpet?
Sure. I think it's important to believe survivors, especially if multiple survivors come out and sort of make the same claims about the same person. I think that can be one way to sort of think about this. I do think that, and when I talk about the due process standard, it's not to disbelieve the survivor when she makes her allegations, but rather to provide the accused with an opportunity to provide a defense on his behalf or on her behalf, given the case. So I don't think they're inconsistent. I mean, you can take survivors' claims seriously while also taking seriously the obligation to allow the accused an opportunity to defend himself or herself. I mean, those don't seem to be inconsistent. And I do worry that, at least as the Me Too movement initially unfolded, and I'm super supportive of the movement, but there were in some cases what seemed like an incredible rush to judgment. And in those situations, I'm sort of reminded of like the Scottsboro Boys, the lynch mobs of the 1930s, and maybe it's hyperbole, but those threats don't seem hypothetical to me.
Particularly now, they seem to be where racism really does appear to be in vogue again. They are really things that we should be worried about. But to get to your point, I think it depends on what the forum is. If you're talking about a criminal context, then there are certain evidentiary requirements. In terms of when a claim can be credited, what you need to establish to make that out, it can be just based on someone's word that this happened. You don't have corroboration requirements in most jurisdictions anymore, but even if you don't have a corroboration requirement, the fact that somebody makes a timely report or they talk about it in some detail with somebody else can constitute corroboration. And so you again, even in a criminal context, you can have give credit to the person, and they don't have to then prove through a calendar or, I had sex that night. You don't have to have that on a calendar. But
Tobin and Squee.
Yeah, with whatever those names were. To go with what Melissa was saying, that in an accusation, when an accusation has been raised, there should be a level of inquiry and cross-examination and determination if this is a credible claim or not. And which is why I said that I fully expected when Anita testified that there would be rigorous cross-examination, because it is, even in that forum, I expected some strong inquiry to determine whether or not this was something that we were going to allow to unravel what might have been a pretty clear path to the courthouse, to the Supreme Court. It didn't unravel anything, but I expected that they ought to really engage in some serious inquiry, because these were serious allegations that were being alleged. So you shouldn't feel that in some ways these things are in tension, that you can't have somebody bring a claim forward, can't question it, And if you question it, that means that you don't believe in a survivor, or you don't believe that this happened or could have happened. But you're testing whether or not this happened with this individual. I think that's perfectly appropriate, but it depends on what your forum is.
Hello. I was wondering if you could talk a little bit about what is in an FBI investigation for a judge, period, because it's brought up that he was investigated so many times. And also, like, somewhat tangentially, like, both of these women seem very highly educated and also, like, very politically aware, and what that means for, like, timing-wise, that they were even able to complain and bring it forward, and what it might mean for people who are, like, less aware that these people are being appointed for not just the Supreme Court, but even, like, lower court judgeships.
I only know a little bit about the FBI process because sometimes the FBI would call me to ask about people I knew, and in a good way, they were up for important jobs. But it was pretty cursory. Like, do you know this person? Do you think this person is truthful or honest? Do you have any understanding that this person might be compromised in any way? I mean, maybe this takes on a different lens with the Russia investigation, but I would just, I would tell what I knew. Like, I don't know that that person has been compromised by the Russian government. I think that person has been truthful to the best, to what I have known of him or her. And it's pretty standard, like, assistant U.S. attorneys go through this background check. Anyone who is taking on a position in the administration would have this background check. I think Dean Morrison had this background check at one point. But I don't think it's not trying to find this kind of stuff, right? Unless someone sort of discloses it. Well, there was this time when Tobin and I were hanging out and this happened. Then they might pursue that. But ordinarily, the questions that they ask aren't meant to surface these kinds of allegations.
And with the Hill hearings, what ended up happening was that Anita did not come forward. She was not questioned in any of his previous examinations when they were trying to make a decision about whether he should be a judge of the D.C. Circuit or at any other level. Her name surfaced with the investigation, that exact investigation. What do you know about Judge Thomas? Asking other people, and is there anything that would disqualify him? And some people said you might want to ask Anita Hill. And so her name came up that way. The FBI went to her, and she asked, can this be kept confidential? And thank you. Can this be kept confidential? They weren't sure that it could be, so she went back and forth about whether she wanted to, but she agreed to be interviewed. She was interviewed for 45 minutes by them, and then that statement was leaked. So she wasn't trying to put this information out there. She actually did not want it to be public in any way. She wasn't sure that this was something she ever even wanted to talk about. But when her name came up and when she was asked about it, she said, okay, and they had her give an affidavit, so she swore to the truth of it. And, as you know, she was polygraphed later, but she told in that instance. So your question, though, is how does the average person who perhaps wants to say something and maybe wants to come forward to suggest something, how would they know? A lot of times they won't know, and that's part of the problem, that we don't get the information that we might want to have, particularly because we're putting somebody in a position for life. You would think there would be a much more intensive investigation, but it tends to be just what Melissa described. We apparently have time for one more question. This is it.
Okay. Over this past week and a half, we've been talking about this issue, and there's been a couple of informal and formal meetings, among the school. And I feel concerned that I have the same question, which is, where are the men? Where are our fellow law students?
Well, they're
I don't know anybody here. I just got here, so I don't know where the men are.
So, it's interesting. I think that what often happens is that we self-select for these, and someone actually came to me yesterday, and a student in my first year criminal law class and said, I wish you had talked about these issues in the classroom rather than in the forum tomorrow. And I said, oh, I didn't want to take up the class time because I knew I was going to be here. And she said, but the people who will come to this aren't necessarily the ones who are in your classroom. And I said, I hadn't thought of that, and I wish I had, because I would have talked about it. So I take your point that maybe this needs to be a broader conversation, and that we need to make sure that it's happening on a more regular basis so that everyone is exposed to it, not just people who feel an interest in it. There are some men in the room, and so I want to acknowledge that they're here. You just may not see them right in that corner, but there's some folks over here, including the one I'm married to. I think that what was displayed earlier is that there's a level of discomfort talking about these issues, but we need to find a way to include everyone in our community around these conversations. So I'm glad you raised it. And I think we're done.